The Santa Clara County Public Defender's Office. We're here for you. We're here to provide legal representation for clients who cannot otherwise afford it. These are clients charged with committing a criminal offense in Santa Clara County.
We are a government agency, but we represent individual clients. In other words, it's not the government that we represent, it's the individual client whose interests are being forwarded by our lawyers in the courtroom.
Both the prosecutor's office and with...
In addition to presenting adults who are charged with crimes, we also represent minors who have had delinquency petitions filed against them in the juvenile courts of Santa Clara County. The Public Defender's Office does not represent people in family court, dependency court, or traffic court. Our office is comprised of over 200 employees, including well over 100 attorneys, each of whom is committed to providing vigorous and quality legal representation to every one of our clients.
Well, I chose to be a public defender because I think it's about the most important job any lawyer could possibly do, to help people who are in trouble, who need help, and who are not in a position to afford it.
People who can't afford an attorney should get equal representation to wealthy people who can afford to hire their own lawyer.
I found that there were situations where you have to go up against a monumental bureaucracy and not know where to go or what to do, and I thought I could help people find their way through that.
Like most of the public defenders in this office, I applied only at this office and was only interested in becoming a public defender. I didn't apply for other kinds of work or other offices because this is where I wanted to work, and this is the kind of work that I'm committed to.
Juvenile cases follow a very specific process. If your child is arrested for an offense committed before he or she turned 18, the police may do one of four things. They might allow your child to go home with you. They might refer your child to a community agency providing shelter, care, or counseling. They might give you and your child a notice to appear, which also details what you need to do and when. And finally, they might take your child to juvenile hall for the purpose of detention.
Like I said,
if your child receives a notice to appear at a meeting with a probation officer, he or she can contact a private lawyer or the public defender to get advice prior to the meeting. At that meeting, the probation officer may reprimand and then release your child without involving the juvenile court. The probation officer might also offer your child the opportunity to participate in a voluntary program in place of becoming involved with juvenile court. Finally, the probation officer may refer your child's case to the district attorney, who will decide whether or not to file a petition. Children who are detained in juvenile hall are allowed 2 phone calls.
Mom? Listen to me. I'm in juvenile hall right now.
The parents are also immediately notified that their child is in custody. The probation officer will decide to either release the child or keep the child in custody. If allowed to go home, there may be restrictions imposed as a condition of the release. If the child is detained at juvenile hall, the law requires that a petition outlining the charges be filed within 48 hours and that a detention hearing be held in front of a juvenile court judge within 1 court day of the filing of the petition. It's important to realize that the lawyer from the Public Defender's Office represents the minor, not the parents.
The responsibility of the public defender in representing a child in juvenile court is to do everything ethically and legally appropriate in terms of protecting their interests. Sometimes it will differ from what the parent wants, but our responsibility is to the child.
If your child is detained, a representative from the Public Defender's Office will interview your child prior to the first court date and then appear with him or her in court. You can call the Public Defender's Office to find out the name of your child's attorney. You are free to ask questions about your child's case.
It's important for parents to understand that as the attorney, we represent the child and not the parents. While we're happy to talk with the parents and to explain to you the procedure, We can't always tell you exactly what's going on in terms of what your child is telling us. Sometimes we're not able to fully explain all aspects of the defense because we are bound by the attorney-client privilege, which means that whatever your child says to us must be kept confidential. And that may seem difficult for you to accept as a parent, but what you need to understand is that if we reveal your child's confidences to you, the district attorney can call you as a witness and force you to testify against your own child, and no one wants to see you placed in that position.
The first court hearing is called the detention hearing. At this hearing, the judge will decide whether your child will be released or held until the next hearing. It is very important that the parents of the minor child appear at the detention hearing.
The minor is here with her parents today.
A pretrial conference may be scheduled after the detention hearing to try to resolve the matter without a trial. If a case cannot be resolved in this conference, a jurisdictional hearing will be held. In this hearing, the judge will decide whether or not it has been proven that your child committed the offense charged,
and that there's a factual basis for the admission. Therefore, I'm going to find that the charges are true.
A jurisdictional hearing in the juvenile courts is just like a trial, except for the fact that there isn't a jury. The parents will be allowed to sit alongside their child throughout the jurisdictional hearing, and the attorney will be there as well. And the witnesses will be called to testify, either by the district attorney or by the public defender, and then they'll be cross-examined by the other side. And at the end, there will be arguments by either side, and the judge will then make the final decision.
If the judge finds your child committed a criminal offense, or if your child admits to having committed a crime, the next step is a disposition hearing. At this hearing, the judge will decide what orders should be made regarding your child. In other words, what should happen to your child. These orders may include, among other things, counseling, educational orders, public service, juvenile hall or ranch commitments, or the California Youth Authority. Your child's attorney will be able to give you further information regarding possible orders. Review hearings are often set to review your child's progress. You have a right to be present at your child's hearing. You will also be given a chance to speak at some or all of these hearings. And you have the right to an interpreter if you need one.
I'm really happy with her. She's really made a difference.
Well, I think there are three goals that we hope to accomplish. First of all, we want to help people move through what's usually a very traumatic experience for them because people don't understand the court process. So we're explaining that to them. Secondly, we're advancing their legal rights for them. But third, and maybe most importantly, we are giving them a voice in the courtroom. We are giving a voice to people who would otherwise feel voiceless in that circumstance.
Whether you've been charged with a crime or have a child who has been arrested, if you qualify, the Public Defender's Office is here to help. Help ensure that your constitutional and legal rights are protected. Help provide prompt and quality representation. Help to thoroughly investigate your case so that you receive the best possible defense. The Santa Clara County Public Defender's Office. We're here to help.